Court does recall the case of the people of the state of Michigan versus Red. So counsel, state your appearances for the record.
Good afternoon, Your Honor. Amy Rice on behalf of the people.
James Thomas for the defendant.
I don't know, Jody, on behalf of Mr. Radcliffe, Your Honor.
All right. And we will continue on with the prelim. Are you ready to call your next witness?
Now, things get interesting. Before even calling the next witness, the defense raises a red flag about what happened off camera. This is where legal drama truly begins.
Prior to calling the next witness, we just want to bring to the court's attention that it was brought to our attention that after the witnesses from this earlier today testified, they joined the room with the live stream. So we had asked for the witnesses to be sequestered. We didn't say we weren't going to potentially recall any of those witnesses, and if any new information came out and it was brought to our attention, they joined into courtroom B.
And that's correct. The witnesses were excused.
They were.
So I told them that they were finished testifying and they could watch the testimony.
And so what is defense's objection?
Our understanding was that the court had asked them to all the alleged victims, the witnesses, to be separated from each other, to be.
I did not order that. They specifically did not. I told you in chambers that was an impossibility. And on the record said that. And specifically indicated that I would be issuing my standard sequestration order, indicating that they should not, those that have testified should not be talking to anybody that has not yet testified.
That is correct.
So if I had ordered that they all be separate, there would have been no reason for me to say that second part.
That is correct. But my understanding is that they were in the room with other family members of other alleged victims that were going to testify later today. And that's one of our concerns, is that they're sharing a space. These people already.
Whoa, the judge isn't messing around. He basically warns, if you accuse someone of tainting testimony, you better have hard evidence. That's courtroom intensity right there.
As came out today, have a lot of connection with each other.
So are you saying that somehow or another their testimony is going to be tainted? Because if you're making that call, you better be ready to back it up, or you better back down from it. One of the two right now, because otherwise I will hold an evidentiary hearing regarding each witness coming up here, and you better be able to substantiate it. So before something else comes out of your mouth, let me know which way you want it.
Thank you, Your Honor. I was making the court aware of the fact that information was brought to our attention. We were under the impression that the court's order was that these witnesses would not communicate with each other in the sense of the testimony. All we're making clear on the record is that these witnesses joined a room full of other family, other members, families, and that's all we're making.
And they were excused. So had we not had that room, had they just been out in the hallway, they would have been out there amongst them anyway. After they're excused, I cannot and do not control them except for the confines of my order, the sequestration order, which tells them not to talk to anybody that has not yet testified.
And all we want to make the court is aware that they were in a room with other family members of those who have not yet testified.
And that means absolutely nothing to the court without more counsel. So I'm done with it.
Thank you.
Well, Your Honor, I would like to speak to the record because counsel is representing that something improper was going on. When from the beginning, I advised the court and counsel that there are approximately 30 people, 8 of them victims to testify. They're all being held in the jury room. I, as an officer of the court, told them not to discuss their testimony with one another. So
okay, go ahead.
They were all in the room together to be kept away from the defendant's family in the hallway, intimidating them. So yes, they are in a room together. The victims are in a room together with family members. They're in a very large jury room together, and they have been since this morning. They have all been instructed not to discuss their testimony.
All right, so we can just put an end to this. Ms. Reiser, as an officer of the court, I'm going to take a brief recess. Can you go down there? I think a couple of the witnesses have walked back in. Can you ask them as to whether or not they had any conversations with anybody who is expected to testify that has not yet testified? And counsel, if you brought that to my attention and you've wasted this court's time, you better hope they say something. Court's in recess.
All rise.
We're back on the record in the case of the people of the state of Michigan versus Radcliffe. Counsel and defendant are present. Ms. Reiser.
Thank you, Your Honor. I did speak with 2 of the 3 witnesses who have testified, the victims. Isaiah and Max are still in the courthouse, but as you are aware, they have been excused. Noah is excused and has left the courthouse. Isaiah and Max assured me that they have not spoken to anyone about their testimony. They've got support from the parents that were in there. But they have not spoken about their testimony, and they are excused, so I did tell them they are free to come back into the courtroom to watch the remaining.
Absolutely are. And just so that the record is also clear, because I went back and was reminded of what was said so that we don't have an obfuscation of what has occurred today and what this court has done. There are 3 separate rooms that parts of this proceeding were going on to based upon the court's initial order closing the courtroom, and then a partial closure, and then a place to put the witnesses and their support personnel. Those are 3 separate distinct areas. So that the record is clear, this is courtroom C. Proceedings have been conducted in my courtroom all day for all of the witnesses in the preliminary examination. In courtroom B, for the first witness, courtroom B was not open, could not be accessed by anyone. And the proceedings that were going on in here were sent nowhere. For the second and third witnesses, which was the partial closure, which the court had ruled on this morning, those individuals, that courtroom opened for the testimony of those witnesses. So while the courtroom itself was closed, except to 2 support people or a support person for the witness and for the defendant, being fair to the defendant, where he had the 2 people in the courtroom B, so that the press and others could see what was going on consistent with case law. That courtroom was open. These proceedings were broadcast into that courtroom. The jury assembly room, which there has been no broadcast to all day and has been absolutely segregated from any part of these proceedings, is where the witnesses and the support personnel, both from, I believe, victims advocates from the county prosecutor as well as MSP, have been sitting all day. So to the extent defense counsel has made any representation otherwise, it is not true. And in fact,
Bang. That's the judge slamming down authority. Translation: stop throwing shade without proof, or sit down. Do you think the defense had a point, or was this just a stalling tactic?
the very fact that they went into courtroom B after their testimony, they could not have commingled with any of the witnesses yet to testify because they're all down all the way at the other end of the building in the jury assembly room. So next time you want to make an accusation, next time you want to make the court follow it, back it up. Otherwise, just be quiet. Call your next witness.
So people would call Christopher.
The court does call the case of the closed state of Michigan versus Caleb Ricardo Smith.
Good afternoon, Your Honor. Raymond Cook for the people.
Good afternoon, Judge Lawrence H. Margolis, on behalf of Mr. Smith, who is in custody.
Yes.